somewhere else. So this is a very difficult dilemma, and it is also difficult on a more personal level that if you are away from your state for 9 years, what kind of jobs can you get when you come back? So here there may be balances between general interest, state interest, and more individual interests. Yes, that is how judges are selected. Which procedures do they follow? One example is transparency, and I refer to the critique in investment tribunals that they are not transparent. Another question is to what extent the court should allow participation by non-parties, by third parties, whether they should allow opinions from non-state actors, amicus curiae, so that also other interested parties can give their opinion, to the extent that the decision also has interest beyond the parties, and very often the judgments will have effects beyond the parties, and therefore these are arguments for giving access also to non-parties. So that is one of the procedural issues that are relevant. How do the International Court interpret the treaties? How far do they go in effective interpretation of treaties, going beyond the wording, relying on the object and purpose of the treaty, expanding the obligations through the interpretation? How far do they go in evolutive or dynamic interpretation, so that the obligations change over time? There we can say that the court has a more legislative function, judicial interpretation, but in fact it to some extent legislate, and of course that may create criticism against the court, that it goes too far. But on the other hand, as I said, it is set there to give decisions that states don't necessarily like. So they must ensure that the treaty or the customary international law or whatever is interpreted effectively, and they must also ensure that the obligations reflect the needs of the time when the circumstances change. So there is a need for a certain dynamic interpretation, but there is also always a question of how far the courts should go, and which may present particular challenges when the political system does not work, like in the WTO, where the political negotiations are blocked. Then it may be more pressure on the judicial system to develop the obligations. And then we have how these courts are controlled by international, regional, and domestic authorities. And there are different ways of doing this. For example, the International Court of Justice reports to the UN General Assembly. The International Criminal Court has an assembly of state parties. The European Court of Human Rights, there are regular ministerial conferences. So there are ways where the states can report back what they like and what they do not like with the court. But it is always a question to have a kind of firewall between the political system and the legal system, but to ensure some kind of communication through the firewall, because courts are dependent on states. If the states leave, they have no clients anymore. But courts are also dependent on their independence. If not, they lose their credibility. So there is a difficult balance there. Moving then to performance. The court should perform in different ways. So one issue is to what extent states comply with the judgments by the courts, here. So if states do not take notice of what the court says, the court is not very legitimate because it cannot fulfill its function. So it is always a question to what extent do states comply and respect the judgments by the court. And that applies to the parties, but it is also a question to what extent states and other actors respect the more general jurisprudence of the court. So that is, it is mainly a question about the parties. But then we can go further and ask about the effectiveness of the court. So these specialized courts, they are often established as part of a treaty, of a regime, and they have functions under the regime. In the sense they shall interpret the treaties and give guidance to the parties, develop the treaties through their interpretation, and to some extent also have some enforcement function. They are not enforcement organs, but they are a threat in the sense that states don't like to be brought before a court. So in that sense, they have an enforcement and shaming function for states. So one can ask to what extent international courts promotes the objectives of the regime beyond the dispute settlement between the parties. But again, we can ask, well, what are the objectives? The International Criminal Court shall promote peace, international justice, alignment between groups of people, etc. And to what extent is a court really designed to do that? And should it do it? Is it not going beyond the judicial function? And then third, we have the meta level. To what extent international courts should promote the international rule of law and should promote even going even further global justice, or is that going beyond what the courts should do? The court main function is to resolve concrete disputes between parties. To what extent should it see its role as promoting the general rule of law, and to what extent should it see its role as preserving global justice? So if we then ask what is the proper role of courts and what alternatives do we have? Well, again, it depends on the function. The proper judicial function is something that the courts are designed to do. They are less good at doing legislation and executive functions. But we can also ask to what extent courts, which the ideal model of a court is two parties resolving a specific dispute. But to what extent are they really a good means to resolve more global public goods problems, like the environment, or peace, or rule of law, or other more public goods? Aren't there other organs that would be better suited? For example, in environmental agreements, we have non-compliance procedures, which have the benefit of being multilateral rather than bilateral cases, which have the benefit of being proactive rather than reactive, trying to resolve the questions before there is a violation, and perhaps to resolve the problems in a non-confrontational way, so that there is no dispute, there is no clash, but there is more of negotiations. So we can think of different ways of resolving disputes depending on the kind of dispute, etc. So it's not obvious that all disputes should be resolved by courts. So the rise and fall of international courts and tribunals. So do we see the fall of international courts and tribunals? I think that yeah, let's take all three of them. I think we continue to need international cooperation. And we need more international cooperation rather than less international cooperation. The international problems of the environment, arms control, preserving peace, there are so many problems that require international cooperation. So there is no solution, I think, going back to national sovereignty only. One can always ask how much judicialization we should have, how many courts, and as I just discussed, there may be different alternatives to courts, but we need courts also. Courts are important to give a final determination of international disputes. We have a long experience with the international courts, and we can point to successes of international courts. So we need international courts as well, and we will continue to need them. So what we have seen with the backlash, I think that developments in international politics goes up and down. Now we are in the phase with critique against international organs, including international courts. That will also change. So I think we should think in the long term. Of course, there may be casualties in the sense that some international courts will not survive, but so far I think we only have one example of a court that has been abolished recently, and that is the Sadek Court, which I mentioned. All other courts have survived, although they have been criticized. We may see that some states may leave courts, but that doesn't necessarily mean a threat to the existence of the court. A special problem is, of course, that the US as an actor is a very important actor, and if the US leaves the WTO appellate body, or the WTO, that may mean a threat to the WTO system, but it seems to me that it is possible also to survive without the US. So that is a challenge, I think, for today's international law, to what extent we can think of solutions without the US in some connections. For example, in the International Criminal Court, we have seen it in the Law of the Sea Convention. They have never been party to the Law of the Sea Convention. They are not party to the Paris Agreement on climate change. So we see several examples where the US is not a party, but where other parties continue to cooperate. And then I think it's important to distinguish between the criticism which is legitimate and the criticism which is more of a political nature. So international courts should listen to justified criticism. They are not perfect, they need revision, but that should be based on the concrete experiences and the facts, so that the changes are for the better. And then it will be interesting to see whether the International Court resists attacks on them, or whether they adapt to these different criticism and change both the rules of procedure to the extent that they have the competence to do so, and also their judicial practice. I think I'll stop there.
Thank you, Professor Sten. I think you have made a very interesting overview of the judicial body in the international society and the many challenges and many dimensions have brought that they are facing today. So now I'd like to open the floor to the audience for questions, comments, and don't be shy. So if you have any questions, feel free to raise your hand. Please identify yourself before you read.
Thank you very much, Professor. I'm a student in Peking University Law School in the first year in my master's degree. And thank you very much for your presentation. And I have a question regarding to the ICC's complementarity principle, because since, as you said, only unless the domestic court is unwilling or unable to adjudicate the case, that the case can be brought to ICC. So some people might criticize that ICC might become an appellate body of the domestic jurisdiction. So do you think that if a country, if a state that accepts to become a member of the ICC, do you think that they accept that ICC would become appellate body of the domestic jurisdiction?
Okay, yeah, that's an interesting question about the complementarity, which is very central to the ICC. So, in principle, there would be no appeal to the ICC, because the idea is that there has been no decision at the national level to be reviewed once again by the ICC. So that is different from human rights courts, where there has been a decision at the national level, and it is a question whether that is the correct decision. So there that can be seen as an appeal to the international level. So the ICC, the Rome Statute, is more a question of allocation of competences, that the ICC can only act, as we have discussed, if there is if the national state is unable or unwilling. But then there can be a question about how the ICC would interpret unable or unwilling. And there are not that many cases about it so far. Many cases, some cases have been referred to the ICC by the Security Council, and then several of the cases have been brought by the states themselves. So there are not much practice on it. But it has been discussed that to what extent the ICC should pay some deference to the national level and give the national level some discretion, some margin of appreciation in determining how to deal with such issues. So that will be a question for the court, how strict it applies this unable and or unwilling procedure. Yeah.
Thank you.
Thanks, Professor. I'm also a postgraduate student of International Law at Peking University. You just mentioned so many criticisms from all aspects, but you didn't talk about their reaction to those criticisms. So I'm curious about how those criticism will affect those international courts, and to what extent, what's their attitudes toward those criticisms? Thank you.
Yeah, that is also a good question. Of course, the recent backlash has happened in a couple of the last couple of years or something. So there is not much practice about that. But if we look back a bit, if we take, for example, investment tribunals, it seems that they increasingly respect national sovereignty more than they did before. So it seems that they have, to some extent at least, taken account of the criticism. Of course, we don't have one investment court. We have several arbitration, and the practice may vary from arbitration tribunal to another arbitration tribunal. But the studies that I have seen say that there is a tendency that these tribunals respect state sovereignty more than they did before. So that I think can be seen as that they adapt to the criticism. When it comes to the International Criminal Court, one should distinguish, which I didn't do, between the prosecutor and the court as such, because the criticism against the court is mostly about the prosecutor and not about the court properly, because the prosecutor has the power to decide which cases to take. So the court as such has not been that much criticized, but the prosecutor and I think we can say that the widening of the scope, the geographical scope, to going beyond Africa, is a reflection of the criticism. So the prosecutor has also taken account of the criticism. The European Court of Human Rights has been also criticized for going too far. It established its principle of subsidiarity and marginal appreciation before this criticism started. But it seems that it has increased the marginal appreciation, and some would say that that is because of the criticism. So I think that in several courts we see that courts listen to the criticism and may also change their practice on the basis of the criticism.
Thanks, Professor Wolfstein. My name is Ji Hua. I got a PhD degree this July from the Peking U. Right now, I'm an assistant professor in China Foreign Affairs University. I have one question for you. My field is quite concerned international environmental law, especially in Paris Agreement and the global environmental governance. Your presentation just mentioned about the international environmental law and the reaction about the international courts and the tribunal. I'm sure you have seen the text in Paris Agreement. Right now, the international tribunals and courts cannot resolve the disputes arising from the Paris Agreement and the climate change. I'm sure in most multinational environmental treaties, like the OZO, climate change, and the Mercury Convention, the science arising from the three main conventions symbolized that the international court and tribunals should decide about the dispute resolution.
Yeah.
So the question, so what is the role of international courts and tribunals reacting to the global environmental governance? Should the IC, international court and tribunals, shrink? Should they shrink in the face of the global environmental governance, or just stand still?
Yeah.
Thank you.
Yeah. Yeah, so the Paris Agreement has some peculiarities in the sense that it is hard law, in the sense that it is a formal treaty, and but on the other hand, the commitments are very soft. So and these such soft commitments about where each state will determine its own commitments and report their commitments is not that easy for an international court to deal with. So it's partly a question of the character of the commitments and the obligations. Generally, in the international environmental law, it has been a reluctance to use courts. The preference has been these non-compliance procedures. In the Kyoto Protocol of the Climate Change Convention, there was this distinction between the facilitative branch and the enforcement branch of the Compliance Committee. So there was a bit stronger enforcement in the Kyoto Protocol, but which is not reflected in the Paris Agreement. So one can say it's a step back in a way. But we see that some of the environmental principles are developed also by international courts. Gachikovo Nagimari's case by the International Court of Justice and nuclear weapons case, there were references to sustainable development. In the Nicaragua, Costa Rica case about environmental impact assessment, etc. So we see that some of the environmental principles are used by international courts and developed by international courts. We see also that some courts are used for environmental purposes, like human rights courts, for example. But we have cases both in the Inter-American Court and the European Court, and I think also in the African Court, concerning environmental cases. So the litigants are using human rights instruments for environmental purposes. So we see in different connections that international courts deal with environmental obligations. And then there has been a discussion for some years whether we should have an international environmental court, and I don't think it has led to anywhere so far. And I'm not sure whether it is a good idea to have an environmental court, because we can use some of the courts for environmental purposes. But it is always this question which I mentioned, whether they are reliable when it comes to environmental issues. But for example, the appellate body, WTO appellate body, has I think used environmental conventions in a quite reliable way. So there was much concern from environmental circles earlier, but now it seems to be it has calmed down. So, but I think it's an open question how to resolve international environmental disputes. That has not been resolved.
Any further questions?